This is Bloomberg Law with June Grasso from Bloomberg Radio.
The liberal city of San Francisco found itself in an unusual position at the Supreme Court this week, taking on the Environmental Protection Agency over sewage discharges into the Pacific Ocean, with a $10 billion fine on the line. The city's attorney, Tara Steele, argued that the regulations were too vague.
They might as well have said, do not violate the Clean Water Act. It doesn't tell us anything.
But the liberal justices pushed back on San Francisco's arguments. Here are Justices Elena Kagan and Sonia Sotomayor.
It's prescribing that you have to meet water quality standards. Like, how more clearly could you meet this statutory language than that?
What they're asking you to do is to become responsible for doing what's necessary.
The ideological divide was apparent, with conservative justices expressing concerns about the fairness of the city facing billions in fines without knowing what its obligations are under a vague permit. Justice Brett Kavanaugh challenged the EPA's attorney, Frederick Liu.
You're suing San Francisco separately for a lot of money based on a standard that they had no idea. At least that's the theory. That's the theory. In your position would allow that.
I don't
yes,
think so.
It would.
I mean, the Bayside complaint is Exhibit A for why what you said is not going to be true.
Joining me is former U.S. Solicitor General Gregory Garre, a partner at Latham Watkins. Greg, tell us about the city's argument here.
So the city of San Francisco is concerned about the lack of fair notice that they have in terms of how to comply with the Clean Water Act as to the sewage discharge that's going into the Pacific Ocean. And their argument is that the Clean Water Act obligates the EPA to set specific effluent limitations on the amount of pollutants coming out of point sources, discharges like the pipes going into the ocean. And that instead, what the EPA has done here is just issued these vague water quality standards. You have to be sure that the water is a particular color where the sewage is coming out, or, it meets other criteria. And the city's argument is that, well, they don't know how to meet those criteria. There's other sources coming in, who's responsible for what. And, all this is against the backdrop of a suit brought by the EPA in which they're seeking, according to the city, literally $10 billion in penalties. So the city feels as though they lack the fair notice that they were entitled to under the Act up front in terms of what discharges could go into the ocean.
Did it seem like the three liberal justices were pushing back on the city's argument?
Definitely. Justice Kagan, Justice Sotomayor, and Justice Jackson all leaned in hard against the city on their arguments. And they took a number of different tacks. Most importantly, I think they really wanted to focus the city on the text of the Act and put the city on its heels in terms of identifying a provision of the Act that stripped EPA of the authority to issue these sorts of broader water quality standards. And Justice Jackson in particular pointed to the language in the Act which says that the EPA could adopt, quote, any more stringent limitations, end quote, and argued that, the city was wrong in saying that the limitations were limited to effluent limitations coming out. The justices also had hard questions for the cities about the potential environmental impacts of the city's position, which at times got pretty gross in terms of talking about floating toilet paper and the like. But the city definitely faced a tough crowd from the more liberal end of the court.
And the EPA's attorney faced a tough crowd from the more conservative justices. Tell us about his argument.
So his argument was that, number one, that the statute did confer this more broader authority on EPA, and that it could be exercised in particular instances, more limited circumstances, and that here he claimed that the problem really was one of San Francisco's own creation, and that he claimed that EPA had asked for specific data from the city about its discharges and the like, and the city never provided it. And so according to the EPA attorney, they had no choice but to issue these more general water quality standards. And, really one of the more interesting dynamics of this oral argument is this was the the city of San Francisco, one of the more progressive jurisdictions in the country, facing off against the Biden administration EPA. And it was clear that there was no love lost between them, at least as to this particular issue.
Yeah, well, this is a case where the city's Board of Supervisors voted 8-2 last week to urge the city officials to resolve the suit quickly. There being a concern that a Supreme Court ruling in the city's favor could have sweeping implications for curtailing water pollution.
Definitely. And it's unclear how far the court would go, even if it ruled for the city in this case. You know, there were justices sort of probing more narrow rulings. And I think, even if the court ruled in favor of the city, it probably would, try to limit the reach of its ruling. But, the basic question on the table is whether EPA has the authority to issue these broader water quality standards, which is something that, as the Chief Justice pointed out during the oral argument, that, this is what the prior regime did. It issued these general water quality standards and set a specific discharge limitations. And in his view, and this is what the city argued, that the Clean Water Act was actually enacted in part to replace that regime with one which gave the dischargers more notice up front in terms of the specific limitations that were permissible.
And did it seem, just as the liberals were taking issue with the city, that the conservatives were taking issue with the EPA?
Well, there was a group of them. There was the Chief Justice, Justice Kavanaugh, and Justice Gorsuch pushed back the hardest, I think. And the main concern that sort of unifying them was the lack of fair notice to the city and other dischargers in this situation where, as I mentioned earlier, potentially these jurisdictions are on the hook for significant penalties, in this case, literally billions of dollars according to the city, and they don't know exactly, the city argues, and the conservatives sort of picked up on, how to comply with the Clean Water Act in this instance, particularly where there are multiple discharges going into the same place. Who's responsible for what in terms of figuring out whether or not the water quality standard is met. But there was some uncertainty, at least, in terms of where the other justices were. Justice Barrett, who actually joined the more liberal justices in an environmental case last term, Ohio versus EPA, didn't join the stronger attack by the other conservative justices and seemed to be probing a narrower angle in dealing with these challenges under the arbitrary and capricious doctrine. Justice Alito picked up a little bit on the government's argument that in this case, the problem was that San Francisco hadn't provided adequate data to the EPA, leaving it with the predicament that it had to issue these more general standards. And Justice Thomas definitely had some tough questions for the city, although his position was a little bit less clear. So, San Francisco coming out of the argument, I think, should feel good about its position, but it's not over yet.
Are other cities in the same position as San Francisco? Have the same problems?
So I think that the use of general water quality standards is definitely not the norm. But one thing that came up during the oral argument in response to questioning from Justice Kavanaugh was that there was, many amicus briefs filed, friends of the court from businesses, municipalities, and the like, who had serious concerns and reservations and problems with the EPA's approach here and, talked about the dangers and lack of fair notice with this sort of more general water quality standard regime. And that was something that resonated with Justice Kavanaugh at least, and probably some of the other justices as well.
This is the first case to grapple with federal agency power since Loper-Bright was decided last June. That's the case that overturned Chevron deference. Though you didn't hear much about Chevron deference in these oral arguments.
No, not a word. EPA certainly didn't ask for it. And, it was clear that this was going to come down to what Congress actually said in the statute and the court's best interpretation of that, which, of course, is the way it works after Loper-Bright and really the way it has worked at the Supreme Court for many years, even before Loper-Bright.
Do you think that we're just not going to hear about Chevron deference in future arguments at all, or about that concept?
We're definitely not going to hear about Chevron deference. I think the more interesting question is, will we hear about other types of deference, so-called Skidmore deference? How aggressive will the government be in trying to claim some type of deference in other cases and try to push back a little bit. And I think that that'll be an interesting trend to follow in the court this term and beyond.
The EPA has faced a string of losses at the Supreme Court in recent years. For example, with the court curbing its ability to reduce greenhouse gases and to protect wetlands. Does it seem like in some respect it's going to lose in this case as well, whether it's broad or limited?
I don't think that that's a certainty at this point. I mean, one of the other questions that came up during the oral argument was whether or not there were some flaws with this case, and maybe the court should just not decide it altogether. But, I think you're going to feel better about the oral argument coming out of it if you're San Francisco than EPA. And I think, EPA and the government more generally has been sort of behind the eight ball in these administrative challenge cases. And, EPA sort of finds itself in a particularly difficult position when you combined aggressive enforcement of its environmental priorities with broader statutory provisions, which is the area where the Supreme Court has been particularly adamant in demanding that the agency point to more specific authority in the statute for what it's doing.
Thanks so much for coming on again, Greg, and sharing those insights with us. That's former U.S. Solicitor General Gregory Garre of Latham Watkins. Coming up next on the Bloomberg Law Show, more than 165 lawsuits filed across the country are already shaping the contours of the presidential election, and more than half are in the 7 states critical for an electoral college victory. I'm June Grasso, and you're listening to Bloomberg.
Election day is in 19 days.
On Thursday, Vice President Kamala Harris was touting early voting in Wisconsin.
Election day is in 19 days, and here in Wisconsin, early voting starts next Tuesday, October 22nd.
And a record number of voters turned out to vote early on the first day in North Carolina and Georgia, where former President Donald Trump was campaigning on Tuesday.
Early mail-in voting in your state is now underway, and early in-person is underway. But I'll tell you what, I'm hearing very good things.
As the candidates battle for votes on the campaign trail, another battle is going on in courtrooms across the country, where judges have already started shaping the contours of the presidential election. They're deciding lawsuits challenging everything from who can vote and how they cast their ballots to which votes count and how the winner is decided. A Bloomberg analysis has identified at least 165 election lawsuits filed in 37 states in the last 2 years, and more than half of those cases have been filed in the 7 states critical for an electoral college victory. Joining me is Bloomberg senior legal reporter Zoe Tillman, who's crunched the numbers. Zoe, did you look at which side is filing more suits? I know that the Republican National Committee said it had launched an unprecedented legal strategy.
We did. And, it's interesting. I think the numbers showed that Republicans and conservatives have been more active in court, more than half, but not overwhelmingly so. And that Democrats and left-leaning groups have also been quite active ahead of Election Day, more typically going in to challenge state laws or practices that they contend are putting up illegal barriers to voting, whereas Republicans and conservatives have been going into states that they feel have been too lax on that front.
The election is a little over 2 weeks out, and there are new cases still being filed.
There are, as issues come up on the ground, we're seeing lawyers at the ready to bring litigation. Interestingly, we've seen the Justice Department getting involved at sort of the final hour, where Alabama and Virginia have announced plans to purge names from their voter rolls based on suspicions that these are not U.S. citizens. And so we've seen not only civil rights groups, but the Justice Department filing suit in recent weeks, trying to stop that from happening. So, I think the later it gets, judges are going to be wary of making any changes that aren't sort of directly related to a late-breaking event. If you're going to court to sue over a law that's been on the books for 2 years, I think the odds of getting judicial intervention now are slim. But I think we'll see cases probably being filed up to the last minute, and then a whole new surge of cases related to what actually happens on Election Day.
In your story, you've divided up the cases into different categories, and nearly a third of the cases focus on who should be allowed to vote.
That's where we've seen more of a concentration of activity from Republicans and conservatives. One of the narratives that's emerged this cycle is this idea that states are failing to do enough to purge people from their roles who are ineligible either because they're not U.S. citizens or they've moved away or they've passed away. I think it's, again, worth noting that for things like non-U.S. citizen voting, the research has shown that that's rare, very uncommon, but it's sort of a narrative that's cropping up in these cases. And then on the flip side of that, we've seen Democrats and left-leaning groups going to court to try to defend who is on the rolls now or expand eligibility. An example of that would be efforts to re-enfranchise people who have convictions on their record. And actually, there was a big decision out of the Nebraska Supreme Court ruling that a state law making it possible for people with past felony convictions to vote, that needs to be enforced.
And we should just mention, states have different laws about whether people with past felony convictions can vote.
That's right. And I think it speaks to sort of a broader theme of this, which is that U.S. elections are this patchwork of different state rules and laws and practices when it comes to elections. So your ability to put your absentee ballot in a drop box in one state might not be the same process as in another. The laws are different, state constitutions are different. So that's always another theme that we see when we look at sort of this broad landscape of voting litigation.
So now let's go to how Americans vote, and you mentioned ballot drop boxes. Republicans have consistently argued against ballot drop boxes, saying it leads to fraud. I mean, has there been proof that there's fraud from ballot drop boxes?
Certainly not in any kind of widespread way. I think instances may crop up of problems in a given place at a given time, but not in the sense that it's proven to be a source of fraud. And we've heard from bipartisan state election officials that this is a time-tested, secure way to vote. But, the pandemic resulted in just an explosion of voting by mail and voting absentee. And states have tried to respond to that, and I think in the past 4 years tried to clarify the rules, but there, have still been fights over, it's not so much can there be drop boxes, but it might be what kind of monitoring does there need to be? Does there need to be a physical, a person sitting there watching when people put their ballots in? Can there be cameras? Where can they be placed? Do they need to be at an official government building? All sorts of minutia, but that make a difference.
Wisconsin, which is, of course, one of those 7 swing states, what's happening there over the ballot drop boxes?
Wisconsin was a really fascinating example where a few years ago, the state Supreme Court had ruled that drop boxes were not allowed under the state's constitution and state laws. And then there was an election. The ideological balance of the state Supreme Court changed, where it went from sort of a more conservative to a more left-leaning majority. Another case came up saying, we think that earlier decision was wrong, and asking the court to take another look. And the court then reversed itself and said, we agree, we think that the previous majority got it wrong, and drop boxes are, in fact, permitted in the state. So that's now the status quo in Wisconsin heading into this election cycle.
Republicans are often trying to make it harder to vote by pushing things like voter IDs. Tell us about the recent case in North Carolina.
The RNC went to court to challenge the ability of students and employees at the University of North Carolina, Chapel Hill, who now have digital ID cards on their phones, basically to say that it needs to be a physical hard copy of an ID. A lower court judge disagreed with the RNC and said that the digital IDs would be fine. There was sort of a round of news coverage of that and headlines saying this would be permitted. And then a week later, the Court of Appeals stepped in and said no and reversed. And I think that was a good illustration of how much power courts have, not just to decide how people vote and sort of what the rules are, but also how much, last-minute preparation and changes election officials have to be prepared to contend with as these cases get decided in the final weeks when election offices have been preparing for months or years for an election to take place.
And also how confusing for voters who think they're going to go to the polls with their student IDs and then find that they can't.
Right. And this is always a big concern among judges as they handle cases, especially in the final weeks and months. And this U.S. Supreme Court has urged federal judges in particular to be quite wary of intervening at the last minute. The risk of voter confusion as well as chaos among the people running the elections. But courts have had to grapple with if, something is illegal or unconstitutional, how do you weigh not acting against the considerations of confusion and chaos?
Let's turn now to which ballots count. And of course, we know that the vote count is not final on election night. So, for example, when voters make mistakes on their absentee ballots, states have different ways of dealing with it.
States have the ability to decide, if you send in a ballot that doesn't quite comply with the rules, do you get notice? Do you have an opportunity to fix the issue? Can you instead, come to the polls on election day to cast a provisional ballot? And that's a fight that we've seen play out this cycle, especially in Pennsylvania, which has laws saying basically if you send in a mail ballot and you don't put a date on the envelope or you put a date that is clearly wrong, you write your birthday, that ballot isn't counted, even if it arrives by election day. And there's been a lot of litigation over that, including the federal level, which is still pending. But, there was another round of state court litigation. We saw lower courts blocking that law from being enforced. But then the state Supreme Court has come in several cases and tossed those cases out, which means that for this election, at least, the expectation is that those undated or misdated ballots won't count. There's a potential for some very last-minute litigation to change that, but as of now, that's the status quo. So I think, again, another example of these rules that on paper might seem very technical or in the weeds, but can end up affecting, thousands of ballots, which can really make the difference in a swing state like Pennsylvania.
More than half of all states accept at least some absentee ballots that arrive after November 5th. So, yes, probably more fights to come on that. Now, we'll move to this area, how the election is finalized. And certification of the vote, was never anything that was talked about before the last presidential election.
That's right. It's long been considered sort of a ministerial role where, as long as the number of ballots that come in match in some reasonable way the number of people who are eligible to vote in that precinct, that they then move on to the next phase of things. And there are ways to challenge ballot counts after the certification process, but that was never really seen as sort of a flashpoint in this process. That changed in 2020 when, after the election, Donald Trump and his supporters, looked for ways to overturn results in states where it appeared he was set to lose. And, pressure campaigns on state lawmakers to intervene and then eventually on Congress to intervene. But it really put new attention on this phase of the certification process at the county and state level as a potential pressure point and a place for supporters of one candidate or another to use their power in a way that it hadn't been used before to intercede if it looks like their preferred candidate is going to lose.
And a judge decided one of these cases in Georgia on Tuesday.
There's a member of the Fulton County Election Board, Julie Adams, who is Republican, Trump supporter, and in May had refused to certify the results of a presidential primary on the grounds that she hadn't gotten all of the information that she felt she needed to confirm that the results were accurate and that the election went off as it should have. And the board overruled her. She was outvoted, but it raised this question of, what happens if a county board does vote to not certify? So Julie Adams went to court and said, I want a judge to tell me that I do have the power to do this. And this week, the judge said, no, you don't, that it's a mandatory duty. And so far, Julie Adams' lawyers have indicated they're not going to appeal this, but we expect this to continue to be sort of a live issue until we see what other local officials do when it's time to cast those votes.
We'll have to see what other decisions come down in the next few weeks that might prevent problems on Election Day. Thanks so much, Zoe. That's Bloomberg, Zoe Tillman. Coming up next, a truck driver wants to use the RICO statute to sue over a failed drug test. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court seemed divided this week over whether a truck driver can use a federal racketeering law to sue the maker of a CBD hemp oil he says cost him his job. RICO, the Racketeer Influenced and Corrupt Organizations Act, is a federal law that was designed to fight organized crime. The question before the court was a narrow one. Did his case satisfy RICO's requirement that his business or property had been injured? Justice Clarence Thomas questioned the driver's lawyer, Isha Anand.
So the injury here is we were fired. That's the injury to our business. Now, as a measure of compensation for that, the damages we claim are an amount equal to the salary we would have made and the other economic benefits that we would have gotten had we remained employed.
But medical marijuana did not fire you.
The liberal justices like Elena Kagan said a plain reading of the law would allow the driver to sue under RICO.
If you're harmed when you lose a job, then you've been injured in your business, haven't you?
But some of the court's conservatives, including Justice Brett Kavanaugh, expressed concern about opening the floodgates to RICO lawsuits.
I think you're saying, yes, the damages from personal injuries can be characterized as injuries to business or property. Therefore, you can just bring them under RICO. That would mean that every state tort personal injury suit in which you're seeking lost wages or medical expenses can be now brought on under RICO and seek treble damages.
The trial judge dismissed the driver's lawsuit, saying his injury was personal and didn't fit RICO, but the Second Circuit Court of Appeals reversed. And why bring a case under RICO? If you win, you can get triple damages plus attorney's fees. Joining me is Brian Wolfman, a professor at Georgetown Law. Tell us about the truck driver's allegations here.
So what Mr. Horn argues is quite simple, that this outfit, Medical Marijuana, was marketing a product. They claimed it had no psychoactive effect and did not contain any THC, which is an active ingredient, as you may know, in marijuana. So Mr. Horn saw advertisements on the internet for Medical Marijuana's product. He himself was a truck driver who, way back in 2012, had suffered a serious injury and had continuing back pain that he was never able to tackle. And he was still a truck driver and really wanted to do something to deal with his pain. And he said, well, look, if this has no THC in it, I'm going to give it a try. Now, why was he worried about ingesting something that had the active ingredient in marijuana? Because he's a truck driver and he is periodically screened for the possibility that he might be using unlawful drugs. So he purchases the product based on the representation made by the sellers that it contains no THC. Lo and behold, Mr. Horn argues apparently it did contain THC, and he goes through shortly thereafter a periodic screening by his employer. It detects THC in his body, and he is immediately fired. And, of course, that's very distressing. He suffers great harm. I'm sure both emotional and obviously financial, because this is his sole means of livelihood, and he has now lost his job. That can be traced to an alleged fraud committed by this company.
Most people think of the RICO statute as it was enacted in order to combat organized crime. So he sues. Why is he suing under RICO?
Well, he's suing under RICO because for many years now, and this goes back decades now, yes, RICO was an attempt to both criminally and civilly to get at organized crime. It's called the Racketeer Influenced and Corrupt Organization Act. But its words, cast its web far more broadly, and I think that was within the intention of Congress. And in any event, its words are much broader, and they encompass civil conspiracies where there is a predicate act, a predicate violation of law that is conducted among numerous people, a conspiracy that imposes intentional harms on individuals. And what it says, and I think I want to point to the part of the statute that's at issue in this case, RICO permits any person injured in his business or property by reason of racketeering activity to bring a civil lawsuit for 3 times the damages he sustains. So let me focus on the key words. Any person injured in his business or property by reason of unlawful activity under this law. And so what Mr. Horn argues is quite simple, that the economic harms resulting from the injuries he sustained are injuries to his business or property by reason of the defendant's violations of RICO. And the reason we know that is because his business was his truck driving business. One's employment is one's business. So his argument is very simple. The Second Circuit Court of Appeals, which is headquartered in New York, agreed with him. And the Supreme Court took this case on because it thought that the courts of appeals around the country had disagreed on this subject.
Tell us about the argument of the defendants here, medical marijuana.
Their argument is that this statute doesn't cover harms that have its origins in personal injuries. And here, because the personal injury or the first-in-time injury was the ingestion of this product that contained THC, even if the ultimate harm is in part a harm to one's business or property, in this case the business of being employed as a truck driver, it doesn't count under RICO because it has its origins in personal injuries, and personal injuries harms are not covered by the statute. The problem with that, and I think this is Mr. Horn's argument, the problem with that is that's not what the statute says. The statute says any person injured in his business or property should recover 3 times his damages. And the injury here in his business, again, I'm repeating myself, is the injury in his employment. In fact, losing all his wages because he was fired as soon as it was discovered that he had THC in his system.
Several of the conservative justices seem to be leaning away from the truck driver's interpretation. Here's the Chief Justice, John Roberts.
Counsel, I understood the business or property limitation as having been intended to be a significant limitation on the reach of RICO. Your friend said that your position would make every slip and fall a RICO violation. Why isn't that the case?
And Justice Brett Kavanaugh also spent some time talking about the fact that there could be sort of an explosion of cases here.
Yes, I mean, that was a concern. So let me explain, I think, the counters to that position that were put forth by Mr. Horn's counsel. The first is, if that's true, that is, that there are more cases that could now be brought under civil RICO. One answer is this is the statute that Congress wrote. And if Congress wishes to narrow the statute and exclude certain violations that are said to have origins in a personal injury, like the injury from ingesting a drug product, then Congress can do so. But I think also the argument is this is not like any slip and fall, because a slip and fall, say, a slip and fall outside a building or at the local supermarket, just involves the negligence, for instance, of a worker at the supermarket not to clean up the floor, so they slipped and they fell. But RICO requires much more. First of all, it requires intentionality, not just negligence. Second of all, it requires, as I said at the beginning, a predicate violation. So not simply that there was the slip and fall, the negligence, but there has to be some predicate wrong. And here the predicate wrong was an alleged mail fraud to perpetrate this wrong, which is a separate federal violation. That would not be true in the slip and fall situation. And there are a number of others, what were referred to as guardrails, on seeing this case as just a slip and fall. Let me give you one other guardrail. It's well understood that an injury in one's business or property does not include emotional harms, what are known in the law as non-pecuniary harms, like emotional harm, pain and suffering, humiliation. All of those things would be recoverable in a typical tort action, in a typical slip and fall. And in fact, in modern American tort law, much of the recoveries in a slip and fall or other kinds of personal injury cases, much of the recovery are those kinds of non-pecuniary damages. They are not recoverable under RICO. So in some sense, RICO gives, but in other ways it takes away. So I think all those things should be taken into account. But I want to come back to the first point. If the court rules here in favor of Mr. Horn, which it may well do, Congress is free to amend the statute to narrow it in a way that it views is appropriate or even that it views as consistent with its original intent.
You obviously feel that Horn's argument is the better one here. But after listening to the oral arguments, do you think the justices were divided or leaning towards Horn?
I don't know the answer to that. it's always difficult to predict for a number of reasons. One reason can be that the judges are just truly looking to answer questions that they're not certain about. And just because they're asking a question from one angle or another doesn't necessarily mean they're leaning one way or another. Sometimes a question that looks like it's coming from a place of concern is looking just for a potential way to narrow the ruling if it doesn't necessarily mean that that justice is planning to rule against this party or that party. So I think it's just very hard to tell. And I think that the court is truly, I wouldn't say undecided, but truly looking for a way to fully understand this case. And I did not take anything one way or other from the questioning. And you mentioned the concerns coming from the Chief Justice or Justice Kavanaugh, and I did not take them as necessarily leaning against Mr. Horn, but expressing some concern over the kind of litigation a ruling in favor of Mr. Horn might lead to, and wondering whether there are any guardrails that might mitigate to some degree a ruling in favor of Mr. Horn.
An interesting case of statutory interpretation. Thanks so much for being on the show. That's Professor Brian Wolfman of Georgetown Law. In other Supreme Court news this week, the court has released the calendar for its December arguments, which will feature 8 cases over 6 days. On December 4th, the court will hear one of the highest-profile cases of the term involving transgender rights. The justices will decide whether states can outlaw gender-affirming care for minors, taking up what has become a politically polarizing issue across the country. On December 2nd, the court will hear a case over the Food and Drug Administration's efforts to ban flavored e-cigarettes. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.